ask all of this up front. Okay, we're about to go into the hypotheticals. It's 2 o'clock. Do we want to take a break? I think we're allowed 10 minutes per hour for a break. Or do we want to plow on ahead? Crickets. Plow on ahead then. Okay. Hypothetical number 1. And look, if you need to go up and hit the caffeine in the back, you're not going to offend me. So this is your hypothetical number 1. You're a new lawyer. You've just received your bar license and you're opening your own firm. You're going solo for the first time and you want to start advertising to attract clients. So as a smart practitioner who uses technology, you take bids to create a website. I'm looking to adding your site a referral service that lists lawyers practicing in specific areas of law. You want to market yourself as, let's say, a defense attorney. And you want a defense attorney referral service. So, here are the questions. How is your website treated by the rules of professional responsibility? And what rules apply? And are referral services permissible? And does it matter how they work or if and how they charge? So, can anyone answer the first question? Any takers? Ed, how is your website treated by the rules of professional responsibility?
It's treated very well. I believe it's 1.6. One of the rules, is that correct?
Yes.
All right. And website.
How do the rules treat a website versus other communications?
More strict.
Try that again.
Less strictly. But
What?
you have to put disclaimers on there. I'm willing to concede before.
Isn't it the same?
Yes.
Just like what we could do in person is the same. What you can do online is the same. What you can do on email is the same. What you can do on any other one.
The one important caveat is I think with personal injury cases there is an additional restriction on in-person solicitation.
Right, that hospitals.
Right. That aside, it's the same. It's a trick question. It's a red herring. The same. In terms of what rules apply, all of them. So there's even been an advertising opinion on it. The rules of professional conduct apply to lawyer solicitation on the internet. Those are 7.1, 7.3, 7.4, and 7.5 since we're talking about advertising. But 1.6 applies as well. There's a comment to Rule 7.1 that says it governs all communications about a lawyer's services, including advertising. So that means there are other communications aside from just advertising. And then, generally speaking, Rule 7.1 only exempts non-commercial speech by lawyers from its reach. So is First Amendment person, you do have some free speech rights here. It's just has to be non-commercial speech. So this is where Hunter versus State Bar hung up, was this was commercial speech. He was only posting victories on his commercial website. It's not like he's going out onto Above the Law and writing anonymous articles. He's using this for commercial gain. And that's going to be the big, or a big potential grasping point for Rule 7.1 is, are you sending a friend, an electronic message like, oh, hey, I won this case today, I did X, Y, and Z, or are you putting it in the commercial stream? You had a question.
Right along those lines, I've seen an attorney from the other side of the state who has a very large following on Facebook. To my knowledge, he doesn't discuss case results on his firm website. I don't think he has a firm Facebook page. Very frequently, he will post favorable case results to his personal Facebook page. So I get the impression is shared with essentially anybody who would like to be friends with him on Facebook without any disclaimers or any context at all. Is that, could would that be the distinction between a non-commercial versus commercial?
You can,
Where did you look at?
if you can hold off your question until, I think it's hypothetical 6, 7, or 8, we'll actually discuss that. No, that's fine. That's a really good question. And part of it will, commercial or non-commercial, who are you publishing it to? So, I mean, obviously, you can have a commercial, like a law firm Facebook page and a personal Facebook page. My boss does that. You know, we have a firm Facebook profile, and then he has his own that you can't access unless he friends you. So there is a very strict distinction with what he does. Hopefully, we will be able to answer your question a little bit on down the road. But commercial or non-commercial speech is going to be important in the case law. Couple of important things with Rule 7.1a, always tell the truth. It applies to internet sites and cautions lawyers to include, and this is important. So obviously, since we are lawyers and we parse everything out with a fine-tooth comb in terms of grammar, the words selected, I mean, we went to 7 years of school, we learned how to write. So simply saying a statement that is true on its face for the bar isn't good enough, and nor should it be for you. You want to include all of the relevant facts so as not to be misleading by omission. So for example, hey, you know, I got my client a first offender disposition. That could be a really good result, or that could be par for the course, or it could be a bad result, depending on the facts of the case. So that statement is true, but you don't know if it's good, bad, or otherwise. So in general, you're going to have to include any fact that might be relevant to put a statement into context in the commercial sense. So there is a commercial and non-commercial difference here. 7.1b, you've got to put your disclaimer up if you were advertising case results. So I've noticed the choice of the word advertising. Again, commercial versus non-commercial. If you are discussing a case result, only discussing things in open court with a friend on Facebook in a private message, you're probably not going to have the same restrictions as you will if you're posting it on your website for the world to see. 7.1c, if you have an advertisement communication, you have to have your contact information, or, and this or is important depending on how you share it, you have to have the entire communication on file with the state bar with the attorney's information. So can anyone think of why the or might be important in terms of how you advertise? How many people in here have a Gmail account, a Yahoo account, another account that has those really obnoxious banner advertising things on the top? Yeah, everyone in here? That's where that statement becomes important. So obviously you probably can't put all your contact information in a tweet or in a banner advertisement that flashes across your screen. So the bar has given us an out saying, if you want to do that, you got to put the entire communication on file so that we can track you down if someone complains. And then also 7.13, if you advertise, you have to say this is advertising material. However, if you're just communicating generally, directing it at the general public, oh hey, we're a divorce law firm, advertising material obviously wouldn't make sense. If it's general public, you don't necessarily trigger the rule. So question 2. Hey, just 50 minutes until 3 o'clock. Rule 7.3b prohibits lawyer from giving anything of value for a recommendation. So this goes back to, can you use a referral service? Does it matter how they work? So in terms of can you use a referral service? Obviously yes. In terms of does it matter how they work? Can anyone else tell me how it might matter how the referral services work, given this rule? Yes?
Well, certainly if you're paying them for recommendation, or even more complicated, splitting any fee that you would get from any recommendation, then
So does anyone have a problem with you with paying to get a recommendation or with fee splitting to get a recommendation? Anyone think those might be covered by rule of ethics?
Are we talking about recommendation as in this guy's the best, go hire him, or a lead referral as in you're looking for an attorney, here is the number to an attorney?
Both. Let's talk about the last one first.
So this is just lead referrals? It's just standard advertising.
Yeah, but the underlying question is, can you pay someone for a recommendation?
For a lead referral, yes.
And I think that might actually be covered in some of these LEOs. Okay. We're going to get into not-profit referral services. So 1348 allowed a not-for-profit referral service so long as the fees for the service were not contingent on the number of referrals. The referrals are made in a strict rotation, and the operators made no case evaluations. And then LEO 1751 allowed a bar association's not-for-profit referral service to charge a fee based on a percentage of an attorney's collected fee. It relied on a state bar case and appeared to carve out a limited departure from LEO's 1348 rule, who have as a goal of providing access to legal services for the public. So LEO essentially allowed for a shifting fee scale to be paid to the referral service. However, the strict takeaway here, the departure from LEO 1348 was because it was a not-for-profit referral service. Okay. Obviously, you can't participate in a for-profit referral service. You can't pay them to get recommendations. You can participate in not-for-profit referral services as outlined by the LEOs. All right, hypothetical number 2. Your wife brought you a Groupon for a discount massage parlor in Hillside. Clueless as to what a Groupon is, you ask her to explain them to you. You can also apply this to a deal of the day kind of advertising solicitation. So at first you're thinking, okay, Groupon sounds like a good way to advertise and get some business out to your firm. It works for everyone else, but you want to evaluate it under the rules of ethics. So the first question is, can you use Groupon or a similar method for your firm? And secondly, can you use banner advertisements and web-based applications like Yahoo Mail or Facebook Messages? So, first thing you have to know about Groupon is the fee structure. And there are Groupons, and I say older, and by older I mean 5 years. But there are other advertising services that spring up and go away probably every 6 months that use a similar fee structure. But Groupon and other sites similar to that collect a percentage of the price from the buyers. So when you're buying a Groupon, part of what you pay goes to the business, and sometimes the businesses lose money, but they get their name out there. That's sort of how it's supposed to work. And Groupon takes a cut from the buyer. So what you pay for advertising directly relates to how many clients buy the deal, and more importantly, it comes out of the money for the lawyer's fee. As you said, there's a huge problem with that. You can't fee split with non-lawyers. So that's kind of a period the end analysis. Can you use Groupon? No. Can you use any advertising service that splits part of your fee with the service? No. Because you can't share your legal fee with a non-lawyer. And Groupon also retains its share of the price before even giving it to you. So how many people here bill by the hour but collect a retainer up front? Like everybody, right? Can't do that. So basically, they take a share out of your fee before you've billed for it and earned it. That's another trust accounting problem, and the bar really doesn't like those. So can't do that.
Alex, what happens if you
Yeah, I mean, the first question is, are you the lawyer paying Groupon for other people to have a free consult? And the second of is, are you, the second layer of analysis is, are you paying them to recommend someone for you, or are you paying to advertise them? I don't know the answer to that. You might be just paying for advertising at that point. But I mean, let's alter your question. If you, do a little cutout free consultation coupon in the newspaper, does anyone have a problem with that? I mean, as long as you're paying for the advertising, I don't off the top of my head see a problem. So, good question though. And I don't know if Groupon will let you do that. For obvious reasons, we haven't exactly gone to Groupon. So, all right. So question 2. This applies to direct communication from lawyers to potential client. So comment 1's definition of a solicitation is targeted communication, specific potential client offers to provide legal services. So the targeted communication and specific client are important. Exempts directed to the general public from its ambit. So at least in this hypothetical, the banner advertisements are just that. You're not, in a banner advertisement in your email, you're not just sending them to Rob's email or Ed's email. You're sending them sort of across the internet at the general public. Hey, I'm Joe Blow attorney, I do this, and it scrolls across your screen. So the banner ads are probably okay. The little Facebook pop-up ads are probably okay if they're directed to the general public. If they're directed to a specific person, probably not. The trickier question that isn't in the hypothetical is, what happens if your banner ads pop up because someone's search results trip, they're looking for a lawyer? So does anyone have a problem with that? No takers? So first off, did everyone understand sort of what I was saying with the way the banner advertisement were to work? So essentially, some of the way these banner advertisements work is if you're on Google and you're Googling a lot of stuff, Google will track your search history and they will send you targeted advertisements based on what you're looking for. So the question then becomes, if your advertisement pops up as a result of that, do we have an ethical problem with that? Huh?
When you're making choices on how your ads are going to go for whatever service it is or product, you have to pick some criteria. And the way that those sites make money is by making your ads show up as relevant. So there's no way around that.
Yes? Bingo. As long as you're not, as long as your banner advertisement doesn't, pop up, hey, Bob, want a lawyer, I think you're fine. If it's just a generic advertisement that happens to be triggered by search criteria, probably not doing anything bad. Okay. Hypothetical 3. So you get the mail when you get home from work, you're looking through some coupons, and you wonder if you could use some strategies to promote your practice. So here are the questions. Can you offer a prize to like your firm on Facebook, is question 1. And 2, can you offer a prize for people to repin a promotional photograph of your firm on Pinterest or on Facebook or any other similar social networking platform? So can you offer a prize for people to do this? So, any takers? Can you offer prizes for people to like your firm on Facebook? Show of hands, who thinks yes? You have no problem with this. 2 takers. Who says no? You have a problem with this? Okay, a lot more. Short answer is, well, 7.3b probably applies to the situation. This is the big kicker. Liking your firm might be a recommendation under the rules. Maybe. It could not be. I see some shaking heads, I see some nodding heads, but it might be. Giving a prize is giving something of value. So if they're liking you, it might be endorsing you. You're giving them something of value for an endorsement, QED. You probably can't do it. Is there an LEO on this? No, not that I'm aware of. And it all has to do with, is liking your firm a recommendation? Some people say yes, some people say no. I'm very risk averse myself, so that's why you get this recommendation. Question 2 is, can you give someone a prize to repost, repin a photo on Facebook or Pinterest? And that should say pinning a photograph on Pinterest. But pinning a photograph, reposting a photograph, does anyone in here think that's a recommendation? You're putting a photo of a law firm up on your profile. Anyone think that's a recommendation? I don't. Isn't this really just publishing an advertisement for you and you're paying them for advertising? I mean, that's what it looks like to me. Now, it may change if you're on a more exclusive social networking board where you only put up what you love, but generally speaking, I don't think necessarily putting up a billboard is a huge problem. And you can pay for advertising. You just can't pay for recommendations. And to tie it all together, we have the ending slide. Okay, hypothetical number 4. You fight long and hard for 2 years, and you win your first jury trial after an epic 2-week-long courtroom battle royale that included a Tom Cruise-esque cross-examination of the opposing party who did, in fact, order a code red. So you won't let the entire country know that you're the next Clarence Darrow. How can you do this? So we're coming up to your question a little early, Rob. Can you tweet about the case on Twitter? Can you post a public status update on Facebook about your monumental victory? And can you post a public status update on Facebook with a link to a local newspaper article about your underdog win? And finally, does the analysis in 2 or 3 change if you make the post accessible only to a list of your close friends, assuming you have personal relationships with all of them? And 5, can you pin a photo taken of you mid-closing? So question 1, can you tweet about it? Can you tweet about your win? Any takers? Okay, we have a lot of yeses. How many people say no? How many people say it depends? Okay. You two probably have it. It depends. And I want to say we went over this earlier. This is where truth or falsehood by omission is really big. So, and also whether or not this is commercial speech or personal speech. Rule 7.1 for commercial speech basically says you have to give enough facts to place the win in context. Now, can someone tell me if this will be possible in 140 characters or less? Huh?
Post the link.
Okay. I'll buy that. To your case would probably require more than 140 characters, but if you're posting a link to a detailed 200-page essay on your case, I may not have a problem with that. A trickier question is, does it matter if this is a personal Twitter account that's restricted in who it publishes to, or does it just broadcast to the public and can you Google search it? And the answer is probably does matter if it's a restricted communication versus it's accessible to everyone on the internet and their dad. All right, question 2. Same analysis governs. So you got to remember to include enough facts to place the case in proper context, lest you run afoul of Hunter versus VSB. So if you're posting a case result on your Facebook account, obviously it's going to depend on, is this a commercial Facebook account? Is this your personal account? And then more importantly, who are you posting it to? So this question had to do with, can you post a link to an article about your case on Facebook? Comment 6 to Rule 7.1 says, if you're posting the communications of others or publishing them in your own advertisements, you're accepting them as your own. So the short answer is, read the article very carefully. The article has to include all the necessary facts to place the case result in context. It has to give a fair and accurate, truthful depiction of what happened. It has to comply with all of the rules of ethics before you can post it on your site, because you're adopting that statement by posting it. And you might even have to put the disclaimer that it's advertising material and it's a case result. Past performance doesn't guarantee future results. So screen it, include your disclaimers. Now, Rob, before I answer this, what do you think? This question is, can you post about the case result on your personal Facebook profile if it publishes to only people that you already personally know? And I would add the sort of contextual statement, you're not, this is your personal account, you're posting wins, losses, you're posting about your life in here. So can you do it?
I think it gets to a point where it's evident from the example that I gave earlier that it's intended to remind everybody in the network, friend network, that he's in cases. And so I don't see a substantive distinction between that and supposedly more formal and commercial advertising. It seems one and the same, just have to be in the personal Facebook page.
So my question to you is, can you do it?
I would not.
Okay. Does anyone disagree based on the restrictions in the hypothetical? So obviously, if we remove the just to your personal friends and you do it publicly, even if it's your personal account, I would have a problem with that. I mean, does it cross the line? I don't know, but I wouldn't do it myself. But does anyone have a problem if you have a smaller, we'll add another condition on it, you have a smaller friend network, you post wins and losses and a lot of information on your personal account, and it's just to friends that you personally know and actually communicate with? Yes?
At that point, it doesn't really look like advertising anymore. And then you go back to what the court said. It's public information as long as you're not publishing information that wasn't previously made public or involved.
Yeah. I mean, at some point, as long as you restrict your communications enough, you are able to tell people about your life. It's not a blanket gag order. So you may not have to put advertising material on them. It doesn't really involve advertising because it's given to your friends. I mean, your friends already know you. These aren't just random people that you don't know. And this is why it's different. It's just to friends that you know, you communicate with. It's not to the whole world. Now, if you have 2,000 friends, this sort of second layer goes away. But if you don't, if you have 50 friends, like my dad, that he actually talks to, and that's all you're posting it to, it may not be such a bad thing. Yes? Yes. Again, the bar always, and lawyers should always be asking, what are all of the facts, and tell me the facts. So yeah, if you're posting it to your friends and friends of friends, that's different. So the cautious approach is not to do it if that's your setting.
Wouldn't it depend on some degree what you're writing anyway? I mean,
Oh,
if you're
yeah.
writing like Great Day in Court, that's different than, oh, I put O.J. Simpson in jail for
Yes.
6 years or whatever.
Bingo. Of course. If you're just saying I had a good day in court, you may be able to post that publicly. Oh, hey, I had a good day in court today. Did you actually tell what you did? No, you just said you had a good day. I mean, so sometimes I can have a good day in court and not win. True. But a lot of it is going to depend on what you actually post. You know, if it
That's misleading.
depends on if you actually had a good day or not, doesn't it? Okay, so can you, repost or pin a photo of you that was taken in the newspaper? And the basic analysis is, if you're only pinning a photo, you're actually pinning anything about your case? Probably not. You can put photos of yourself everywhere. But check to see what comes along with the photo. If there's a long comment thread of all sorts of commentary on the case, like, oh, the other guy was such a sleazebag, and you're posting that, you may not want to do that. But if you're just pinning the photo and it's a good photo of you, why not? So, and this will recap the best answers I had hoped in one button push, but, Okay. Hypothetical number 5. Your son asks you about a case you're handling. Curious as to how your son knew so many details about the case, you ask him where he heard all the information, and he tells you that someone tweeted about it. So you sign on to Twitter and discover that the opposing party, who's represented by counsel, posted publicly accessible tweets about how your client was a hashtag scumbag and was hashtag lying about the claims he asserts in his embarrassing slip and fall injury and fracturing of his tailbone, how the jury will think he's a liar, and how he wants to talk to you and give you, the lawyer, a piece of his mind. So, here are the questions. First question, can you tweet in your client's defense? Can you defend your guy? Second question, can you call the opposing party and give him a piece of his mind and let him give you a piece of his mind? And then 3, does the analysis change if this is a criminal case where you're prosecuting, you're called a scumbag, you and the victim are in cahoots, lying about deliberately hosing down a floor with caustic industrial-grade lubricant to cause slip and chemical burn injuries in order to ratchet up convictions for the upcoming election next month. So does the analysis change if it's a criminal case? So first question, can you defend yourself? Obviously, the rules come into play. So the first question in analyzing whether or not you can defend yourself is, do you have to give up confidential information to do so? So if revealing details about the case to defend your client not only is without his consent, but if they would embarrass him. So not only does it give away something, tip your hand on your case, but it's embarrassing. I mean, and that's sort of the first step analysis. Is falling and breaking your tailbone embarrassing? I would think so. So you probably couldn't do it without your client's consent, even if the information is public knowledge. So this is where we've been having the back and forth about Hunter and the open court versus not open court. This case is pending, so it hasn't gone to trial yet. This is potentially embarrassing information. Your guy falls and breaks his bottom, okay? And that's pretty embarrassing to me anyways. Even if 100 people saw it, you need your client's consent before you start defending him on Twitter. Yes?
Didn't you say that the guy writing this stuff was represented by, like the guy tweeting this stuff, did you say he had an attorney?
That's the next question. We'll get to that in a second. No, that's a great question to ask. And I actually don't know if I included that in the fact pattern. But for purposes of the hypothetical, assume that he has a lawyer. And assume that the lawyer has not called you. But basically, before you defend this guy, you have to talk to your client first and get consent. Second, obviously, you're going to have to watch what you post and make sure it wouldn't contaminate a jury. So, ask your question again.
I thought that you said that the guy was represented, and I thought about tweeting back to him, would that be considered text messaging or communication with somebody who's already has a attorney?
So, the term that the rules use is, so ex parte is if you talk to the, I know what you're getting at. So if you talk to the judge and no one else is there, but it's communicating with a represented party is what the rule is. And the bottom line is you can't. And the interesting about this hypothetical is the client, the other party himself, is inviting you to communicate with him. So does anyone think that if he is inviting you to communicate with him, that's a problem without looking at the screen? Yes?
He's allowed to try to contact me, you're not allowed to respond.
You're absolutely right. So this is the crux of the rule. If you have a party on the other side who has a lawyer, and this is how I like to think about it. You're a lawyer, he isn't. So he can contact you all day long. He's not breaking any ethical rules because they don't apply to him. He's a party. I mean, unless on the off chance he's a lawyer, maybe they would, but assuming he's not, they don't apply to him. They apply to you. Two, the other attorney is actually who holds, I don't want to say holds the privilege, but holds the ability to give you permission to talk to their client. So this also kind of goes back to the GAL question earlier. This is why the GAL send out the letters to the attorneys. It's because the attorney has to sign off on you talking with their client. Even if the other client is saying, talk to me, I'm going to give you a piece of my mind, however tempting that may be to get him to spill his guts about the case, unless the other attorney is giving you permission, you can't do it. So.
Can you respond and say, I can't talk to you because you're represented, or even that be too much?
In responding, aren't you talking back to him?
Well, I guess it would be more if they, not Twitter, if they actually came up to talk to you.
So in-person communications always present an interesting challenge because for obvious reasons, they're there, they're in your face, you can smell what they had for dinner. It's usually very uncomfortable, but the rules are pretty strict. You can't talk to them if they're represented. Now, is anyone going to hold it against you if you tell them, hey, I can't talk to you, you have a lawyer, rules of ethics forbid me from talking to you? Probably not, because you're telling them, I can't talk to you. But beyond that, you can't really say anything. You just have to kind of take it. Which stinks, because we all want to defend our client, but this isn't in the courtroom yet. So unless the other attorney says, dude, tell him off, then you probably can't do it. You definitely can't do it. So does this change if it's a criminal case? Do you have any criminal defense attorneys in the room? Any other criminal defense attorneys? Okay. So, and we know we have a prosecutor or a former prosecutor in the room as well. So this question is sort of focused at y'all. But does the analysis change at all if this guy is essentially accusing the prosecution of fabricating a crime and trying to ratchet up convictions for an upcoming election? What can you say to combat that? Rule 3.6, so you go to a totally different rule now. Rule 3.6 governs prosecutors and defense attorneys concerning pretrial publicity for jury trials. Jury trials. So if this is a district court case, does this analysis change? Maybe, maybe not. Because you do have no juries in district, but you have a right of appeal. So the smartest thing to do is assume anything is a jury trial and go from there. Rule 3.6 says you can't say anything that you know or should know will have a substantial likelihood of interfering with the fairness of trial by jury. So you can't taint your jury pool. You can't try your case in the press. Now, they had a case that came up about this in Nevada. It held the First Amendment allowed a defense attorney to respond to a prejudicial press conference to defend his client against jury taint. So in Gentile, I want to say the prosecution in the sheriff's office, held a press conference. There was some pretty bad stuff with the guy's client. And Gentile actually took to the press and defended his client because you don't want jury taint. And Gentile essentially said he's got a free speech right to do that, and the ABA carved out a safe harbor. Two wrinkles in this case analysis are obviously we're Virginia, we're not the ABA, and we don't have a safe harbor. And in this case, can the prosecution defend themselves from the accusation of misconduct? So in Gentile, it was a defense that was defending itself, and in this case, it's the state. So what's the safest thing to do? Yes?
Let it go.
Yeah. That's the safest thing to do. So, I mean, obviously you can say he's charged with X, potential sentence is Y, but other than that, your standard press release, you probably shouldn't say anything. So question 3B, essentially the defendant in the case has asked the prosecutor, hey, come and give me a piece of your mind, and essentially the exact same Rule Point 2 analysis applies. There's an additional rule just for prosecutors because they like putting extra rules on us. It's also implicated, and it tells prosecutors not to take advantage of an unrepresented defendant. So basically, if anyone in here ever becomes a prosecutor, you can't take advantage of people without a lawyer. You have to play fair. So does anyone see, and let's tweak this a little bit. Assume this guy is not represented. This is a pro se defendant. It's a misdemeanor case, and this guy's tweeting and saying, hey, I want to give you a piece of my mind. Does anyone have a problem with the prosecutor going and talking to the unrepresented party defendant? Do we need defense? Yes.
I think it would depend on the circumstances. I mean, if we're still talking about responding on Twitter, I would not recommend that under any circumstances. Talking about an active pending case on Twitter, that's just a stupid idea.
Oh, I agree. But is there anything ethically wrong with it, assuming they're unrepresented?
About plea deals and things of that nature too. So there has to be an ability for prosecutors to speak to unrepresented defendants about the case. They have to be able to do that. Because if they're representing themselves, they're their own counsel. You have to be able to speak to their own counsel. So if they want to sound off about something, that's fine. You take that as an opportunity to listen to what they have to say. But there's nothing. I wouldn't go about it then, though, to give them a piece of your mind. What are you going to gain on the video?
Well, and here's the other question, the sneaky question that's under the line. Is it taking advantage of an unrepresented person to give them an opportunity to sound off about their case or i.e. their strategy to you? Does anyone have a problem with that? Yes?
I think it's a can you versus should you. Maybe technically can, but should you know it's risky because the perception is that you could take advantage of them even if you don't. And so you kind of jeopardize your case by engaging them. Plus, if they just want to sound off and give you a piece of their mind, it's not going to be a real productive conversation anyway. So I would just avoid it altogether.
Everyone kind of agree with that analysis because it's a solid analysis. So go through the best answer slide. Yeah. Okay. Hypothetical number 6. You are the premier expert on federal litigation and write profusely about legal matters on social networks. One day as you're writing general information about how to avoid harming a potential ERISA case from the start on your Facebook feed, which is open to the public. Your email address is not on your Facebook account, but it is on your employer's website. Later, a person from Schenectady, New York emails you and says they took your advice, did what you said, and gave you a detailed description of their employment-related defenestration and ensuing ERISA case. Is So here are the questions. One, has this person become your client? Two, can you represent the insurance company if they hire you to represent them in the same case? So, who thinks this person might be your client? Any takers on that? I hope not. So they haven't paid you, they haven't signed a contract of representation, you didn't send them a targeted solicitation saying, hey, come be my client, so probably not your client. But the analysis is slightly deeper than that, so lawyers and people can give out legal information but not legal advice. So we can all give out legal information to anybody. We can tell them the First Amendment guarantees your right to free speech. It's a crime to drive drunk in Virginia, but you can't cross the line into providing legal advice, which is when you start applying the law to their specific fact pattern. So obviously giving information is not practicing law. There's a string cite for that. You should also use disclaimers on your website. If you look at this information and use it, we're not creating a client. The ethics opinion recommends using disclaimers to disavow the creation of an attorney-client relationship. And if you're doing this for your website, you use a click-through disclaimer. Meaning something pops up on your screen and says, look, you understand by going on the site, you're not creating an attorney-client relationship. Click here if you understand, click yes. Does anyone really read them is a separate story. For this situation, you're just putting it out there in the public. You're not soliciting them, so they're not your client. They haven't signed your attorney-client agreement. They haven't paid you. They're not your client. Okay. Question number 2 has to do with prospective clients. And it also has to, this is a Virginia-specific reading of the law. So a person is a prospective client, and the question, if anyone forgot, was essentially, you posted sort of an article on general information about ERISA cases and things you would want to do, maybe not want to do at the beginning of your case. Posted to the public. Someone contacts you from New York and says, hey, I took your advice, help me out. So under Rule 1.18, person's a prospective client when they consult or communicate with a lawyer about the possibility of hiring them. Obviously, you owe them a duty of confidentiality too. And Rule 1.9 limits how you can disclose the information to others. And the crux of this, can you represent the insurance company and then use what the person told you against them? Rule 1.18b disqualifies a lawyer if they get substantially harmful information from a prospective client, but the disqualification does not impute to the firm. So you can theoretically be glass-walled off from the firm if there's even a conflict. But takers, do you have a conflict of interest if this person gives you all of this information after you post this big blurb on what to do or not do to hurt your case? Does anyone think you might have a problem? No takers? Yeah? Okay. Now, why do you have a problem?
Well, if the insurance company is an insurance company,
Yeah.
hire you, you know information that there's an expectation of privacy from the person who gave this 100%.
Okay. That is the safe analysis. However, the Virginia rules of ethics generally hold that unsolicited communication doesn't create a reasonable expectation of confidentiality or creates prospective client status. So I would agree with you 110% if you'd sat down, had the client consult with the person in your office, we're talking, hey, my hourly rate is this, my retainer is this, contingency fee maybe, I don't know, but that, you've sort of reached out to them and set up the appointment. This, you published an article. Let's add a wrinkle. You published an article in the, the docket call, our quarterly newsletter at the YLC. And he's texting. let's say you publish a really good article in the docket call, and someone calls you and gives you all this information about their case, and you don't want this person as your client, to irritate you, whatever. Are you bound by that information in that situation? And really, this internet hypothetical is the same thing. You've posted online. Are they actually a prospective client? Who's soliciting who? You've published an article. So under this hypothetical, no. You didn't solicit that other person to give you all of the negative information about their case, and you may be able to use it against them, actually. So, and this is where I think Virginia might differ a little bit from the model rules. How late do you want me to go, Ed? Because we have 10 minutes and 5 hypotheticals.
Questions?
We've got 10 minutes and I have 5 more hypotheticals to go, but it's kind of,
Feel free to keep going if you would like.
maybe we'll cover this one other one, if it's a good one. This is a quick one, so we'll do it. Okay, you're taking a long way to honeymoon cruise to the Bahamas that you delayed for a year to save the money to pay for it. However, you don't want to return to the inevitable mountain-sized stack of files that you know will be waiting for you when you come back. So you take your trusty MacBook to the airport and figure that while you're on the airplanes, waiting in the airport, you'll do some work. Somehow you clear security in 5 minutes. You don't have to take your shoes, run it through the x-ray machine, and you don't get patted down, and the airport has free Wi-Fi. So, questions are, okay, questions are these. This looks bad, but it's not. Can you use the public Wi-Fi connection while accessing confidential client files from your firm's server and sending confidential emails? Does anyone have a problem with that? Yes.
I have a problem.
Using public Wi-Fi? Okay. Does anyone think there is a circumstance where you can use public Wi-Fi?
I believe and not fully understand how there's a way to get a secure connection to a public Wi-Fi. But I think that only is between your computer, laptop, whatever it is, and the actual router. I don't know that you do anything past the router.
Downloading the file encrypted?
Bingo. If you encrypt your stuff, I mean, this is what the military does, right? You encrypt, they encrypt communications that are sent out over radio waves that kind of anyone can listen in on. And that's, there's a whole history of, encryption, ciphers, what's reasonable. And you do have to use reasonable precaution to keep your client information safe. So if you're in, I don't know, Russia, and there's an internet cafe full of hackers right next door, I wouldn't use public Wi-Fi even if it was encrypted. But, other things aside, if you're using industry standard 256-bit encryption or have access to something more, you might not run into any problems using public Wi-Fi. Now, does the answer change if the Wi-Fi network is a mobile hotspot or your phone is the hotspot?
Still not that secure. More secure, but less.
Then can you talk to your client over the phone?
Yes, but Wi-Fi again, less.
But I'll explain the fact pattern. Your phone is, or the hotspot is serving as the Wi-Fi mode, not the airport's Wi-Fi. So it'd be like if I took out my hotspot, can I use my own hotspot? And the answer is, as long as the data is sufficiently encrypted and protected, yeah, you can use your own stuff. As long as someone else can't easily break into it. If you make your hotspot public Wi-Fi, you're probably hosed, but if it's just you, you're probably okay. 3, yes, it does change if you encrypt your stuff. And 4, does it change if you work from home with your wireless Wi-Fi router attached to your personal internet provider? You can probably do that, as long as your Wi-Fi is password protected and no one else can use it. And then 5, which is not an outline, does proposed Rule 1.6D or Comment 19 change this analysis at all? The answer is no. We're all talking about reasonable precautions to prevent a client data breach, which is essentially what the rule asks us to do. So that's a trick question. Any other questions, comments, concerns, or anything else? Crickets. All right. Well, thanks for having me for 2 hours. Sorry it wasn't quite as exciting as before lunch, but